So wow, Diddy seeks acquittal or a new trial, and here's why. But first, the quick reset. On July 2nd, the jury cleared Sean Diddy Combs of racketeering and sex trafficking, but found him guilty on 2 counts under the Mann Act for transporting people to engage in prostitution. Bail was denied, so he's been sitting in the Metropolitan Detention Center while the clock ticks towards sentencing on October 3rd. That mixed verdict matters. The heaviest allegations didn't stick, yet 2 narrower counts did, and those 2 are exactly what his lawyers are attacking now. They filed a post-trial motion asking the judge to either toss the convictions or run a new, cleaner trial focused only on the Mann Act issues. Prosecutors say, "Nice try. The evidence was plenty and we should move straight to sentencing." So the stage is set, a split result, no release, and a hard calendar date. The only question is whether the judge lets this train keep rolling or pulls the brake and rewinds the last chapter. But that isn't the whole story. The defense's emergency move isn't just about timing, it's about what the law actually means. So here's the play. Diddy's team isn't nibbling around the edges, they're asking the judge to wipe the board. First choice, a judgment of acquittal on the 2 Mann Act counts. Failing that, they want a fresh trial limited to those counts without what they call the extra baggage from the broader trafficking storyline. It's filed as emergency because sentencing is set, he's still in custody, and the clock is loud. The subtext is simple: don't sentence him on verdicts that, in their view, never should have happened. Why is it unusual? Because post-verdict relief is a steep climb. The defense has to show either that the law was applied the wrong way or that the trial was so tilted that the only fair fix is a do-over. They argue both. In law, they say prosecutors stretch the meaning of prostitution past the statute's lane. On process, they say the jury was swamped with material tied to charges he beat, plus that 2016 surveillance clip, creating spillover that tainted the narrow transport counts. In short, wrong rule book and a messy game. If the judge agrees, he can pull 2 levers: toss the convictions or rerun the Mann Act piece with tighter guardrails. If he doesn't, we head straight to October 3rd. Either way, this motion is the last exit before sentencing. Now to the heart of the fight. What even counts as prostitution in this case? This is the hill the defense picked. They say the Mann Act wasn't meant for this exact setup. Consenting adults, no pimping ring, no brothel, no profit. Their reading is narrow. Prostitution should mean sex for hire in the classic sense. Someone selling to a buyer, not a private scene where escorts are paid to spend time with the girlfriends while the star of the show watches. They even reach back to 1910 when Congress wrote the law, arguing the word has shifted over time. The pitch to the judge is simple. If the term's meaning moved, courts should use the original understanding, not a modern catch-all label. They also poke at the only one of its kind angle. Name another case, they say, where a person was convicted under the Mann Act for arranging travel so adult escorts could be with adult girlfriends in private, with no commercial enterprise attached. If the answer is none, they want the court to see this as overreach, and they press the timing point. If payments happened after travel, can you really say the purpose of the travel was prostitution at the moment of booking? Light sarcasm moment, because yes, they go there. Paying for the setup isn't the same as buying sex. That's the line. If the judge buys that, the statute looks too broad here. If not, the label sticks. But the defense doesn't stop at definitions. They try to wrap the whole thing in free expression cloth next. Here's the framing. The defense says some freak-offs were filmed, everyone was an adult, and the point wasn't commercial sex, it was private adult content. If that's true, they argue the activity leans toward expressive conduct protected under the First Amendment. In their telling, Diddy wasn't running a sex-for-sale operation. He was a voyeur, sometimes recording consensual scenes that looked more like amateur adult videos than prostitution. Label it performance, not commerce, and the Mann Act starts to look like the wrong tool. Prosecutors hit back with a blunt reply. A camera doesn't convert a crime into speech. The statute keys on the purpose of travel. If people were flown in to engage in paid sexual activity, that's the ball game, filmed or not. They also push against the voyeur-only claim, saying the record shows planning, directing, and payment structures that look exactly like arranging sex for money, regardless of who's on camera or off. So the fault line is clear. The defense wants the judge to see art, or at least private expression. The government wants him to see transport for paid sex, period. And even if you don't buy the First Amendment angle, the defense says the timing and intent still don't add up. This is the needle the defense keeps threading. Intent. The Mann Act isn't about random travel plus later bad choices. It targets travel arranged for the purpose of prostitution. So they argue the government never nailed the timing. Yes, money changed hands, but if escorts were paid after the trip, that doesn't prove Diddy booked flights because of prostitution at the moment of booking. Correlation isn't intent, it's a timeline problem. They press the logistics too. Some travel was handled through assistants or girlfriends. That adds distance. If others handled the details, how certain are we about what Diddy intended when a ticket was bought? The defense leans on that gap. They say prosecutors stitched a story from patterns, freak-offs, hotels, payments nearby in time, but patterns aren't the same as proof of specific purpose. The government's answer is simple and blunt. The pattern is the proof. Repeated fly-ins, hotel setups, coordinated schedules, testimony about who directed what. Stack it up and the intent looks obvious. You don't need a memo that says purpose, prostitution. The calendar and the receipts already say it. So the jury saw a trail and called it intent. The defense calls it guesswork. And that brings us to their other swing. Even if you think the evidence was enough, they say the way the evidence came in tipped the scales, and what they point to next is the spillover claim and that 2016 video. Here's the fairness pitch. The defense says the jury sat through weeks of heavy testimony aimed at racketeering and sex trafficking, charges Diddy beat, and that heat spilled over onto the narrower Mann Act counts. Add the 2016 surveillance clip they fought to keep out, and you've got, in their words, a jury primed to see smoke everywhere and assume fire. They're asked, run a new trial on just the transport counts, minus the extra baggage that wouldn't belong in a standalone prostitution case. They frame it as a classic Rule 33 problem. When evidence meant for big ticket charges gets bundled with smaller ones, the mix can tilt the room. If jurors heard graphic stories tied to allegations the government couldn't prove beyond a reasonable doubt, how do we know that vibe didn't color the verdict on the travel counts? That's the spillover prejudice label. Too much unrelated shock, not enough clean focus. Prosecutors push back hard. They say the jury already proved it could separate by acquitting on the top counts. That's the opposite of a runaway verdict. And as for the 2016 video and similar material, the government's line is that much of it still matters for context and intent. Who planned what, who paid for what, and why the travel happened at all. In their view, this isn't an emotional play, it's how you show purpose. So we're at a fork. If the judge thinks the trial's join everything structure bent the scales, a do-over on a tighter record makes sense. If he thinks the jury sorted it just fine, then the verdict stands and the schedule doesn't budge. Which sets up the next question, what can the judge actually do? And how soon, with October 3rd staring everyone down? 3 doors. Door 1. Deny the motion. That keeps the convictions intact and the train runs on schedule toward October 3rd. Door 2, new trial on the Mann Act counts only. Same dispute, tighter record, no extra baggage, the defense says tilted the room. Door 3, a judgment of acquittal, rare air, but it's on the table if the court thinks the law was misapplied or the proof flopped on intent. Timing matters because he's in the Metropolitan Detention Center, and any ruling changes what happens next week, next month, and on appeal. If the judge says no, expect the defense to press these same arguments upstairs at the Second Circuit after sentencing. If he says yes to a new trial, we rewind and replay just the transport counts, likely with stricter evidentiary guardrails. And if he goes all the way to acquittal, the Mann Act piece is gone, clean cut. Either way, this decision sets the tone. Is this a cleanup of a messy trial, or proof that the original verdict can stand without a crutch? And outside the courtroom, the reaction split tells its own story. The split is loud. Some viewers see a sharp legal play, argue definitions, squeeze intent, and strip out anything that shouldn't touch the Mann Act. Others call it a word game before sentencing. Rumors suggest a chunk of the audience thinks the amateur content angle is clever but thin. It's been said the stronger pitch is the spillover claim. Cleaner record, cleaner verdict. Industry chatter frames it as a stress test for a 1910 law meeting a 2025 lifestyle. Supporters point to consent and adult choices. Critics point to flights, hotel setups, and money, then ask how that isn't transport for paid sex. Brands stay quiet. Comment sections aren't. And with October 3rd on the calendar, the narrative isn't drifting, it's tightening, which leaves one thing: what happens if the judge calls it one way or the other? Here's the bottom line. If the judge says no, this heads straight into sentencing and the appeal lane opens after. If he says new trial, we replay the narrow question, travel and purpose minus the extra heat. And if he goes for acquittal, the case resets around everything that's left in the larger timeline. So was this motion a lifeline or just noise before the gavel? We're about to find out. Watch the clock, watch the docket, and watch whether the definition fight lands with the court. Because if this ruling redraws the lines on what counts as prostitution under the Mann Act, it won't just be a headline for the week. It'll be a reference point the next time celebrity, lifestyle, and century-old law collide.